Hey guys, it's our Shawn. Welcome to today's topic of dealing with minority investors. This may be something you, as a business owner, are dealing with. It's something certainly I, as a practicing lawyer, deal with a lot. It's something we do a lot of structuring around, we do a lot of talking about, we do a lot of planning for, and then we do a lot of negotiation on the back end because regardless of how well you plan this, there's always potentially issues out there. Plus, I get a lot of clients that contact me after the structuring was done. Things have progressed, the business has built. Usually, there's some success going on in the business. And then these minority investor issues start to pop up. So they are quite common in the business world. They are really built into what we do and how we grow as entrepreneurs. So there's nothing wrong with you if you're dealing with minority investor issues. Yes, there are things you can do proactively in the beginning to make these things better. We'll talk about some of those. So that even if you're dealing with one of these situations, as you grow and expand, I'll give you some tips and tricks and things you can consider moving forward to minimize or lower the risk of these issues flaring up. But they are a natural part of business. They're part of the legal process of managing and growing a business. That you can expect these will happen. So don't beat yourself up. And I give you that same advice regardless of what's happened in your business. You can't go back and change time, but you can get better going forward. So maybe you've dealt with these in the past. Maybe you're afraid of these in the future. Maybe you are in the middle of one of these right now. Regardless of where you see yourself sitting, we're going to have some ideas for you and hopefully avoid you getting into these issues in the future. Now, as always, this is not legal advice. I don't even know your specific legal situation, obviously, over YouTube. I am just giving you tips, tricks, and ideas, give you some entertainment, give you some education. You need to consult an attorney of your choosing on your specific situation and get some real legal advice if you're dealing with one of these live situations. And hopefully this video educates you so you can have a better conversation with your attorney. The starting point of all of this is, what do your agreements provide? Uh, and again, we're not really diving into your situation, and I don't even know your situation. We're not even doing anything state specific, right? Whether it's a Delaware corporation, a Texas LLC, a Florida entity, whatever it might be. The starting point is, what do your agreements provide, right? So you're going to need to go grab those out of whatever files you have. Some people have better files than others, but you need to figure out what was agreed among the parties. What happened? In an LLC, it's that LLC agreement that's so critical. I tend to bake a lot into the LLC agreement myself. I tend to, have one single document that is a critical piece of how the company runs. I've seen other lawyers out there use multiple documents in LLC formation. Whatever the case may be, you got to look at those fundamental agreements among the owners of the entity. Same flies for a corporation. If you're dealing with a corporation, again, what do your documents provide? What did you do? Now, you may have seen my videos previously on forming an LLC versus forming a corporation. If you haven't, they're right here on the channel. So subscribe, go back through our past video library. You'll learn a lot, including some of the fundamental differences between an LLC and a corporation. But the corporation generally has more structure than the LLC. So the default rules of whatever corporate code you're dealing with in a corporation case will probably have some more impact on what agreements can be made, how they work. LLCs tend to be more freedom of contract, so the agreements will probably be more important. So regardless of which category you're in, you got to get familiar with what everybody signed and what everybody agreed to. There will be some legal analysis of, were they done properly? Are they fair agreements? Are they enforceable, right? So you need to look at that too. But the starting point for jumping up is, or jumping out is, what did we agree to? How are we going to work this situation out? In many cases, when you get these legal forms online, or maybe you copy and paste something, a lot of times these minority stockholder issues were not fully thought through. Again, this is one of the reasons why you want to get experienced counsel involved earlier, to anticipate and to put some of these issues to bed before they become issues. But We just got to we got to figure out where the cards are laid, and we got to deal with it, right? So it's never time to look back and point fingers unnecessarily, right? What we want to do is keep moving forward. So, if you're in one of these situations, you probably have a business with some value to it. So congratulations on that. Keep it moving. What you want to do is you want to manage the business to avoid flare-ups if at all possible, right? So there's a lot of things we can do to avoid minority stockholder issues from becoming issues even in the first place. One of the best things you can do is have some corporate transparency. Most of the time I see minority stockholder issues is because of lack of trust and lack of transparency. So the minority investor usually feels like they're entitled to more money or they're being wrong because they just don't know what's going on. Now, there is some natural tension in the business, right? Let's say we have majority owners of the business that are also the officers and directors. And then we have some minority investors that are kind of passive investors. There's always a tension because the officers and directors are probably going to pay themselves for their services to the company, draw a salary, and pay themselves for their time, whereas the other investor just has a financial investment. So anything paid out in salaries to the officers, directors, feels like it's moving money from one shareholder to another. This is where transparency, openness, accountability, and maybe even getting some third-party reporting can be so valuable, right? Are you paying a fair salary? Have you documented that it's a fair salary? Maybe you got a third-party report on compensation that says, yeah, we're paying the officers the right amount, right? These are all little things that can be done to manage the business to avoid flare-ups. And that's what I want to recommend to you is as you're considering minority investor issues, maybe you already have them, maybe you're trying to avoid them for the future. I hope you're on the more proactive side. If I had to pick the two, I'd prefer to be proactive. But I want to manage the business to avoid the flare-up, right? It's terrible when you get in these fights. So what I want to do is I want to set my business up and have my business established so that these problems never even come to the table, right? In the best of all worlds, I've got a situation where the minority investor never gets so upset that they're going to run to the courthouse, right? They know what's happening. They can rationalize it. Their fears are assuaged. They can understand what's going on. And they don't run to the courthouse. They never feel aggrieved, right? So there are ways we can certainly manage the business to avoid flare-ups. It's never 100%. Humans are humans. Some people just have that litigation bend. Some people want the trouble. But we can avoid a lot of these flare-ups just by managing the business the right way. You also want to have, provisions in your documents that avoid some of these things. So, again, if you're sitting here and you're already in a full-blown flare-up, you're on the eve of litigation or you're in litigation, it's hard to renegotiate the documents. But if you're building the business or if you're in a situation where maybe you've had a little tension but it's passed, you can go back and visit your documents and get some provisions in there. Specifically talking about how votes are done, what rights and protections the minority investors have. What protections do they not have to give the majority of the business to act quickly, right? There's a tension always between the minority investor being able to block things and being protected versus the business practicality of keeping things moving. One key thing you can do is put buy-sell provisions in there that can be triggered that allow the business to be bought back, on some formula, maybe a third-party valuation. But the point being, what you'd rather have happen in most cases is in the event of a minority investor issue, you'd rather just buy those shares back, consolidate the company in less owners, and keep moving forward versus going into protracted litigation, right? So there's provisions you may want to put in your documents that, again, open up that transparency, clear the visibility, protect the minority investors from being overrun by the majority investors, but then also allow the business to go forward. So you're threading a needle in a way, but you want to get those provisions in your documents. And if you've maybe had a flare-up or two, you want to avoid more flare-ups, be a great time to go back and amend the documents. And in general, assuming there's no third-party loans or other restrictions on amending the documents, generally the owners, especially if you get 100%, can come back and amend the documents so you can re-level the playing field even after you've started playing the game. Just like if you look at a major sport, they change their rules usually every year. There's some rule change or two to make the sport safer, more competitive, TV timing, whatever. There's always edits to the rules, and you can do the same with your company. Just like a major sports league would change their rules every year, you can edit your company rules when the time is right to deal with situations you've seen and to avoid future situations. So I recommend that as a strategy. What if your documents aren't optimal? Well, you're in a tough spot, right? Because you can't edit it usually without certain consents. And, you could potentially get more than 51% in some cases to amend documents. That would open up the door to perhaps a minority investor, saying you aggrieved them or you took their rights away. But you may decide that risk is better than having a lot of deadlocks. You could then look at bigger options, like what do we do, right? It becomes a negotiation and a strategy session. Do you want to continue the business? Maybe the majority owners that are officers in our prior example, maybe they don't want to keep being officers and working for the business if they're not getting sufficient income, right? Maybe they want to vote to close the company down. We can certainly see that, and sometimes it would be better to close a company down, as much as I hate to see that happen to a business, than to go through protracted litigation, right? Because litigation gets very expensive and it's hard to stop. Once you've started litigation, particularly if you have claims going both directions, it's hard to stop it. So that's an option if your documents aren't optimal. There are also some sophisticated corporate strategies out there that you could potentially do to push a minority investor out. We're talking here about a merger or a squeeze out. Now, those are fraught with litigation risk because the minority investor will see what's happening. They may not be happy with getting frozen out or squeezed out, but it is an option as well. So there are things that can be put on the drawing board to fix things that may or may not be appropriate in your situation. So you really want to do an evaluation of what really makes the most sense from a risk-reward standpoint, a business continuity standpoint, protect the value. So, again, I don't want anybody beating themselves up about their documents. What I want everybody doing is taking a look at it and hopefully taking a look at it from a more rational standpoint. That can be one of the hardest things in all of corporate legal practice is, thankfully, it's not family law, right? We're not dealing with children. Not dealing with people that are living in the same household, and a lot of stresses come into the family law practitioners. But in corporate law, my client still, tends to be somewhat emotional. You've got time and energy in this. You do probably have personal financial issues tied into it, including, maybe loan guarantees, etc. So you've got to lay the table and figure out what's best. Hopefully you're taking a look at this from a cold, rational business standpoint of maximizing your long-term income and prospects. So if your documents aren't optimal, it's time to think about renegotiation or what your options are under your documents. All of this is going to lead into a negotiation. And, I obviously negotiate for myself in my personal life, but most of my time, or a lot of my time as a lawyer, is spent as a professional negotiator on behalf of my clients. Taking positions back and forth. And that is an interesting thing about being an attorney is, we negotiate on behalf of other people, which gives us a level of disconnectedness, but it changes the nature of the negotiation too. I'm not in there negotiating for myself. I'm not as emotionally connected to the outcome. I want the best things for my clients, obviously, but I can talk differently. And so there is something to be said for bringing lawyers into the process. It's definitely going to increase your costs, and it can be costly to have an attorney negotiate, right? I want to be very realistic with that for everybody. that having an attorney come in and do your negotiations is not cheap in most cases, but it allows a level of sophistication and negotiation that can't happen. It does potentially facilitate things that would never happen one-on-one. One problem with one-on-one direct negotiations from people that are upset with each other is, you can't test offers the same way through you can through an attorney. You can't talk theoretically. You can't pre-test litigation strategies, right? That's really what happens a lot of times with the attorneys is we're talking about, well, what would your client accept? What would your client accept? What about this theory? What about that theory, right? So there's a lot that happens behind the scenes in an attorney negotiation that doesn't necessarily happen at the same time in individual negotiation. But the point is, if you're in there and you've got a good attorney that knows how to negotiate, that negotiation process may avoid litigation. But of course, ultimately, and I've been in this situation a lot, at some point you have to figure out how much you want to bend, because both sides are bending in a negotiation. The question is, do you bend enough to get to a deal, or does it feel like you're bending too much? At which point you have to say, hey, let's just go to litigation. And again, zooming back to the documents we talked about earlier, if those documents were more lengthy and more detailed or more specific, they may include details on how a dispute resolution happens. And that may be an arbitration, maybe litigation in a certain court, maybe mediation before arbitration, etc. Right? So some of our negotiation process may have been pre-established before the dispute arose. So we got to play with that. And then the other options are, what do you do if the negotiation breaks down, right? And again, we may be back to some of those other things we talked about before. Merger, sale of the company, squeeze out, right? There's a lot of options for what you do. And what you really want to do is you want to view this as a process. And so what I'll typically do with my clients is we'll collect information, we'll assess the situation, I'll lay out options with risks and benefits, different paths, and then we'll figure out which paths we want to pursue in which order, right? It's really it's a study. It's a negotiation. I don't know a better way to say it other than you're negotiating back and forth with the other side. So you've got to see what their positions are and probe and learn and test to try to get to a resolution. But what you also want to do is you want to know what you're going to do if you don't get to a resolution, right? I don't think there's any secret to that other than, the good attorney knows what a lot of the options are before the negotiations go in, right? You know your exit path before you go in. It's like the wise person that would tell you, when you go into a theater, you figure out where the fire exits are. Same with a negotiation. You're going into the negotiation, you want to make it work, but you also want to know where the exits are if it doesn't work, right? Before you get too deep into it. Being tough may be key, right? So sometimes in negotiations, you got to stand firm, and that may mean that you end up in litigation. I typically am one to try to avoid that if possible. Litigation is not pretty. I'm a transactional lawyer primarily. I do help my clients with litigation sometimes, usually through another lawyer. But we've got to sometimes stand up to the possibility that we may end up in litigation, especially if we have poorly drafted documents, if we have problems from the past. The worst case scenario is you're going to end up in front of a judge or jury, and you may have to face that reality if the other side's being unreasonable. Now, maybe going through the litigation process, starting all that, all the paperwork and time and expense that comes with litigation may over time motivate everybody to settle. And I've had some cases go deep and get closer and closer to trial, and then eventually parties say, okay, let's knuckle under. And maybe sometimes you're learning information as you're exchanging documents, but you've got to figure out how tough you want to be, and that's a client by client decision. I lay the options out for my clients. Honestly, I'll be as tough as they want me to be, and I can be when I have to be, but we have to figure out what's realistic and what the cost benefit of it is. You are not alone if you're having minority stockholder issues, right? You are one of many that are facing this. And so don't, cry into your pillow at night. Don't feel like you made the biggest mistake ever in business law. Many people, including some very famous people, have been on this bridge. And it is a time and a place. And, with luck and skill, that's exactly what it'll be. It will be some place that you were in the past, but you are no longer in the future. And then, like I say, in the future, there's things you can do. There's never 100% guarantee, but there are strategies in place to minimize the chance of ending up back on this bridge. So, hope that gives you a good overview of some of the minority investor issues and how to work them out and what the options are. I would love to hear your comments below about what you've seen, what issues are out there, and really what you're doing proactively to try to manage this. So drop all that in the comments below. Would love to read through it. I'll respond back to you. I try to respond to most comments. And if there's future videos you need, let me know. All right, folks. Shawn. I'll see you again soon.